I think we're now ready to resume. Mr. Aronson, can I just go back for a moment to the point that was troubling me before the short adjournment, just to make quite sure that I've got this clear in my mind. If we're considering a UK parent with a UK subsidiary, the UK parent receives dividend income from the subsidiary, which carries a tax credit, and the parent can then use that tax credit to diminish its liability to pay ACT. So if, for example, it was otherwise due to pay ACT of 100 and it had 100 of tax credits, it would pay no ACT. If we envisage next a UK parent with a foreign subsidiary, it again received the dividend income, but this time there was no tax credit, subject to anything it might obtain under a double taxation treaty. And so if it were liable to pay ACT of 100, there was nothing to set against it, and so it paid the ACT of 100. And so prima facie, you have a claim, it has a claim to recover the 100 that it paid as unjust enrichment of HMRC. But as I understand it, it is now understood to be entitled under EU law to a tax credit in respect to the foreign dividend income. And that tax credit is still available for it to use. Yeah. So if next year, for example, it were due to pay otherwise, if it were due to pay tax of, say, 100, then it could use the ACT, I beg your pardon, it could use the tax credit to diminish that liability. Have I got that right?
Yes.
Oh,
as far as I understood, the tax credit basically goes all the way up the corporate tree.
Yeah.
And then until it eventually reaches the outside shareholders.
Yeah. Thank you very much.
That is the system of, that's how 231 operates. Whenever there is a payment, unless there's a group income election, the tax credit just simply keeps going up and up and up and up until it reaches the outside shareholder, Lord Sailors.
Yeah, it's my fault. I may now be becoming confused about exactly how this works. I thought that the EU tax credit gave you the measure of the ACT that was paid, which was unlawful ACT. In other words, you don't retain the EU credit for use in future as well. It's the EU credit which tells you how much of the ACT paid by the UK parent company was unlawful ACT.
That's correct. That is correct. But the recipient of the dividend that has carried the foreign tax credit, then when it pays further dividends up the chain, Section 231 and Section 241 operate. It doesn't matter how many links in the chain there are. There could be six. It could be a six-tier company. It goes up and up and up until it reaches the outside shareholder, which is the whole purpose of the imputation system, to alleviate the economic double taxation that would otherwise impose tax on the corporate profits and tax on the shareholder at the top.
You see, I understood this to be the point that Lord Briggs was putting to you before the short adjournment, that under section 231, the receipt of a tax credit by the parent company is in no way a trigger for the shareholder to receive a credit for the notional rate of ACT. So as I understood the point that he put to you, and I understood you to agree, and speaking for myself, it seems right. The way section 231(1) works is to give the shareholder of the UK parent a tax credit, an automatic credit against its own payment of income tax or whatever, equivalent to the rate of corporation tax applied with respect to the amount of the dividend that's been declared.
Yes.
So if that's right, I mean, it's another way of making the point I was just seeking to put to you, that the fact that there's an EU credit, there ought to be an EU credit for the parent company, is in no way a trigger for or causative of the credit that the shareholder gets under section 231 subsection 1.
That is correct. That is correct. It's not a trigger for it, but its exonerating effect feeds up through the chain.
Yeah. So in a sense, you start at the end of, you could say you start at the end of the chain. The shareholder of that UK parent is going to get a credit equal to the ACT rate applied to whatever dividend is declared in their favour. And as my Lord Briggs put to you, when the shareholder fills in their tax return, they have all the information. They know how much dividend was declared. They know the ACT rate. Right. And so they claim that credit in their tax return. Yeah. They don't have to look at what in fact was happening below the receipt to them.
It should be printed on the dividend slip very often, just what the rate of credit would be.
So they're getting the benefit of that ACT credit, whatever happens down the chain.
Exactly.
What is significant down the chain is that the revenue is getting payment of that sum from someone else. So when ACT is paid by a UK subsidiary, the revenue has received that money, and there is a FII tax credit that works its way up the chain. But the fact that there is that tax credit working its way up the chain is not causative or triggering of the benefit that the shareholder gets at the end, because they're getting that anyway.
Exactly.
And as I understand it, what happened, the main thrust of the EU case law here is to say, well, since the whole system is aimed at alleviating double taxation or profits that enter at the bottom of the system and then work their way up and come out at the top, and when you're dealing with that from a UK subsidiary perspective, that's dealt with because the ACT is paid by the UK subsidiary. The thrust of the EU case law is to say that same logic should apply on a non-discriminatory basis to the corporation tax that's being paid for a non-UK subsidiary, so that the same logic that there shouldn't be double taxation of the profits entering at the bottom, it works its way through in that way, and so you get the EU tax credit, which is applicable relevantly for the UK parent company to set against its liability to ACT. But again, I mean, I appreciate I'm labouring the point that that's not a trigger or precondition for the shareholders' tax credit, which they're getting in any event.
You're quite right. The shareholder tax credit simply follows from the fact the shareholder has received a dividend. How much ACT is paid down below depends entirely on how much ACT was paid in a lower tier, if there was, or how much corporation tax was paid overseas. It's as straightforward as that. Your Lordship's expressed it, if I may respectfully say so, extremely clearly. Yes.
Right, thank you very much.
You agreed with me 5 minutes ago that the ACT was paid by the UK parent because of its non-receipt of tax credit in respect of its foreign dividend income.
Yes.
And you agreed with me that it is now entitled to that tax credit on its foreign dividend income.
Yes.
Yeah. The result of which is to diminish its tax liabilities now in a way in which, if our law had conformed with EU law, they would have been diminished back when the ACT was actually paid.
I'm not quite sure about your timing point, my lord. I'm missing it, I'm afraid. If I can respectfully ask you to.
Yes. Well, simply as I understand it, you've agreed with, the ACT would not have been paid when it was paid if an adequate foreign tax credit had been received.
Yes.
Yeah. But because they are now entitled to that foreign tax credit, it's available now to be used to diminish the tax liabilities they would otherwise have.
No, it should have been. It should have been available at the time.
Yes.
So you say it's available now because the courts have declared it, but
yes.
If you reconstruct, as we did in our CT61 spreadsheet, we reconstruct it, it would have been used at that time.
Yes.
ACT would have been spared, but the tax credit would have gone through to, I feel like a school teacher with hands being raised all over the place.
Well, Mr. Anderson, could I try? Because I did notice what seemed to be an inconsistency between what had been said to Lord Reid and what had been said to Lord Sales. Now, am I right that the only credit that the companies are getting for the non-compliance with EU law is the monies that come out of the claim for unjust enrichment? You have no separate credit being given to you by the Inland Revenue, is that right?
Yes, that's right.
Yes. So as far as the company is concerned, the company isn't getting a credit and also an unjust enrichment payment.
No.
Well, I think that was what Lord Sales, that was your answer to Lord Sales, as I understand it.
This is extremely helpful. I'm left utterly bemused by the way the Court of Appeal has expressed issue 17 on page 904. The way it's put, HMRC enriched by the payment of ACT when it was required to give corresponding tax credits to the recipients of the dividends. Well, as I understand it, from what you've just said, Lord Hodge, although they ought, in principle, under EU law, to have given such tax credits, they didn't in fact give them. They're not now required to give them. The issue is simply irrelevant.
No, I think, with respect, my lord, I may be bemusing you. The Court of Appeal said, it's right, the tax credit goes to the shareholder because the shareholder received a dividend from a UK company. It's that's straightforward. Whether the company paying the dividend...
Well, hold on. You're talking about tax credits received by individual shareholders, not by the
funds or what? Yes,
not by the parent company.
Yeah.
Okay.
I think the Court of Appeal understood that, because at paragraph 243, they say can they deduct the tax credit? They had to allow the shareholders to whom the distributions were made. Now, the distributions in this case are from the parent company up to the shareholders. It's making of a distribution that attracted the old ACT.
Well, that's the question. The relevant distributions, one might have thought, were the ones being made by the foreign company to the parent, which presumably not. I think that's been the source of misunderstanding.
But what triggers the ACT liability in the first place is when you make a distribution to your share.
Exactly.
Yeah, I think we're there.
I don't know which of us is the most confused, but I think we are. I think we are there. I think we're on. And I'm sorry if I've said anything that sounded inconsistent. Probably I didn't quite understand the question. Right. So where we have got to is that ACT is in principle payable whenever a dividend is distributed by a UK company. In principle it is, but the calculation which may lead it to zero depends on whether it has indeed in turn previously received franked investment income. And the shareholder, the outside shareholder, which is what this question is dealing with, this is issue 17, isn't it? What issue 17 is what the outside shareholder is getting in the case of an income tax payer as a credit against his income tax, in the case of a pension fund as a repayment, in the case of a foreign shareholder, maybe nothing. Depends on a double tax treaty. And that just follows from the payment of the dividend to the outside shareholder. And how much ACT has been paid to HMRC is not affected by the amount that goes to the shareholder outside or vice versa. And that's really what all this is about. And as I was saying, if you just assume a very simple case where within the group before the payment goes out to the and when the dividend is paid, the paying company pays too much ACT. It just gets the arithmetic wrong. The shareholder gets its credit based on the amount of the dividend, not on the amount of the ACT. You could have put a naught after, you could have put a decimal point in the wrong place. It makes absolutely no difference. So that's the point which I'm seeking to make. What is important is to appreciate the point I was making, that this alleviation of double taxation, economic double taxation, is not a red herring. It is the whole purpose of the imputation system. And that was tested in the case my learned friend mentioned but didn't actually take me to, which is the BT Pension Fund case. Now, the BT Pension Fund case was not a case within this GLO, but it is a consequence of this GLO. You remember the FID issue, the franked investment dividend issue. Franked investment dividends were introduced as a means of reducing the ACT problem in 1993 or thereabouts. And they operated by when a company was paying a dividend which it could attribute to an overseas source of profit down in a subsidiary. The company paid the ACT but could get it back as soon as it demonstrated to the revenue that those profits could be attributed to an overseas company. That was the foreign income dividend system. However, HMRC rarely gives with one hand without taking at least as much back with the other, quite necessarily to protect the public finances, of course. The corollary of accepting a dividend or attributing a dividend as a foreign income dividend was that the outside shareholder didn't get a tax credit. Now, that was noted in passing in FII, CJU1 and CJU, which dealt with this. That was noted in passing, but it wasn't one of the specific issues that was raised, apart from the context of whether the standstill provision applied, you may remember. There was no dispute that the FID rules were themselves in breach. However, that case did not involve the outside shareholders. So the outside shareholders brought their own case, and the test case for that was the BT Pension Fund case, which you'll find at Authorities Volume 2, tab 23 in the paper version, and EF page 3934. And to summarize the result was the Court of Justice held that the outside shareholders were entitled to receive, that's the pension fund, were entitled to receive the value of the tax credit in cash. They were entitled to receive it, even though no ACT was paid. This was the revenues argument, was because ACT was repaid, there was no actual final payment of ACT, then the outside shareholders couldn't complain. Now, the logic of everything I've been saying this morning leads us to the conclusion that that must be wrong, that the shareholders are entitled to their tax credit, and that is indeed exactly what the ECJ said. And it's worth picking this up with the Advocate General at page 3947. Advocate General Watterley, Judge Watterley, who changed his role from judge to Advocate General. The paragraph 64 on page 3947. According to the United Kingdom government, under the United Kingdom's imputation system, there was a direct link between the tax advantage granted to the shareholder, namely the tax credit on the dividend, and the ACT paid by the company in respect of the dividend. The United Kingdom government points out that in accordance with the logic of that system, because ACT on a FID, on a foreign income dividend, was repayable to the company, the shareholder was denied tax credit. In my opinion, the justification which the United Kingdom government puts forward cannot be accepted. It's no more than a reiteration of similar arguments which that government put forward and which the court rejected in the case which gave rise to the test payments of the FII group litigation. So as I say, it's exactly the same argument the government has been running. This was in 2018. Been running it since 2006, and it's wrong. You can pick this up at in the CJEU at paragraph 34 of their judgment at page 3959. It's referring to previous paragraph, the FII litigation in the second hearing. Paragraph 34. Thus, the court has held in particular that to the extent that the United Kingdom tax system, including the FID regime, deprives shareholders receiving dividends of their right to a tax credit, where those dividends originated in the foreign source profits of a resident company, contrary to what was provided for in the case of dividends which have their origin in the nationally sourced profits of a resident company, that system established a restriction on the free movement of capital within the meaning of Article 63, the TFEU. And then if we move on to paragraph 35, no, where am I? Yes. Paragraph 37. It follows that the trustee's situation comes under the treatment referred to in paragraph 173 of test claimants of the FII group litigation, which is precluded by Article 63. They may thus rely on that article for the purposes of disapplying a national provision such as Section 246C, that's the FID provisions of the Act, which deprives them of a tax credit. And then paragraph 42. On the contrary, dealing with the revenues argument, The unfavourable tax treatment of certain shareholders receiving dividends treated as FIDs, namely the absence of a tax credit provided for in Section 246C of the 1988 Act, is precisely due to the fact that those dividends have their origin in the profits that the distributing company has received from a non-United Kingdom resident company. Whereas in the case of dividends which have their origin in the profits received from a United Kingdom resident company, those recipient shareholders would have been entitled to such tax credit, all other things being equal. The United Kingdom government argues that such a restriction is in any event permitted insofar as it's justified by the need to ensure the cohesion of the national tax system. However, suffice it to state in that regard that it's apparent inter alia from the FII litigation that the restrictions of 63 found in that case could not, in the court's view, be justified by the need to preserve the cohesion of the tax system at issue. As has been observed by Advocate General Waterley in point 66 of his opinion, the arguments put forward by that government in the course of the present proceedings are essentially identical to the ones which were rejected by the court in that latter case. Consequently, they cannot justify in the present case the restriction of Article 63. So you have it in the clearest possible terms that EU law mandates the payment of the credit to the outside shareholders. HMRC cannot say, the United Kingdom cannot say, we were not enriched by the payment of if we repay the ACT, we would not have been enriched, and we were not enriched by the ACT because we paid the tax credit. They just can't say that. Tax credit had nothing to do with the ACT. It may be, I found it very helpful. This isn't false flattery, it's genuine flattery. I found the judgment of my Lord Reed in the ITC case extremely refreshing in that I could understand it. It pulled aside the strands and dealt with each strand, the payments from the managers and the payments to the investment trust company itself separately. And it was doing it that way made things very clear. But there's a very helpful paragraph. I've already alluded to it. It's in A111, authorities 111. And it's at paragraph 42. And I'd just like to read it. It's at page 3391. It's talking about analysing considering the very basic principle behind unjust enrichment. 42. The structured approach provided by the four questions does not therefore dispense with the necessity for a careful legal analysis of individual cases. In carrying out that analysis, it's important to have at the forefront of one's mind the purpose of the law of unjust enrichment. As was recognised in the Minalao case at para 23, it's designed to correct normatively defective transfers of value, usually by restoring the parties to their pre-transfer position. I'll emphasise that and come back to explain why I think that's very helpful. It reflects an Aristotelian conception of justice as the restoration of a balance or equilibrium which has been disrupted. That's why restitution is usually the appropriate remedy. So we know that the payment of the ACT was normatively defective. That needs to go back. Payment goes back to the test claimants. That restores the parties to their pre-transfer positions. The revenue haven't in any way had their wealth diminished by the payment of the tax credits. It's as simple as that. The repayment of the ACT restores the parties to the pre-transfer position, to the position they would have been in had there been no normatively defective transfer. And then in a single sentence encapsulates my whole submissions on this point. Before moving on to issue 18, which I will deal with in very few words. Can I, just for the note, invite you to record that in Pirelli, the Lordships made repeated reference to the link between Section 247 and Section 231, i.e. when Section 247 applies, a group income election is made, there is no credit under 231. Relating the two statutory provisions together. It's important because my learned friend relies on Pirelli and sort of emphasises the bits in Pirelli that say that there is this unspoken link between ACT and tax credits. The fact is there was a spoken link as well, and it's the spoken link that is the critical one when one stands back and now looks at this sort of more historic. And the spoken link saying you cannot have a tax credit under 231 if you are making a group income election. Lord Nichols, paragraph 11, which is EF 3482. Lord Hope, paragraphs 33, 35, and 39 at EF 3487 and 3488. And Lord Scott, paragraph 67, which is EF 3496. And in one of those citations, one of their lordships said that that's the critical point. My lord, what says?
I mean, I suppose you would say that the use that the revenue are trying to make of Pirelli in the present proceedings is in substance trying to go back to the argument that was rejected, you say yet again, in the BT pension fund case, which is to say that the tax credit for the outside shareholders at the end of the day is a feature of a system predicated on ACT, whereas the European Court has, as you say, repeatedly rejected that analysis and has said no, what you have to look at the system as being directed to is alleviation against double taxation of corporate profits entering at the bottom of the tree and exiting at the top. And if you look at it in that way, the credit to the outside shareholders at the top is not predicated upon the operation of ACT or collection of ACT up the tree. Whereas, as I rather understood Mr. Ewart's arguments based on Pirelli, he was trying to say that's absolutely the key feature of the system, which grounds his submissions in relation to issue 17.
Yes.
Is that a reasonable way of putting it and encapsulating your response to his submissions on Pirelli?
I would say that reasonable understates. I think it's an excellent way, if I may respectfully say so. That's exactly.
And you, in addition, you make your points, the specific statutory points on Pirelli, which, because of the operation of Section 247, which was what had happened in Pirelli, you didn't get into Section 231 at all. Therefore, Pirelli provides you with no guidance for that reason as well as to what happens with Section 231.
Exactly. There was no European right engaged in Pirelli apart from the ability to make the group income election under 247. There was no credit given for any overseas tax. It didn't arise. That was actually the origin of why I started writing the judgment chronology. I just thought, well, let's set it out. Where does Pirelli come? It comes at a time when no one was even thinking about tax credits. And certainly ACT4, which was looking at tax credits in the direction of the outside shareholder, overseas shareholder from a UK company, rejected the proposition that there was any tax credit to be given.
Yes, thank you.
I haven't taken you to ACT4, but that is simply what it says. And was it, and this is, I can assist further, can I move to the issue 18, whether, assuming everything I've said is wrong, the cavalry comes to the rescue, the European cavalry comes to the rescue, and the principle of effectiveness, so that you cannot pray and aid the defence of no enrichment or subjective devaluation or change of position or anything like that. Lady and Kidd tells us that where you have a right to a recovery of tax, which is a Saint Georges right, there are no defences to be given apart from the defence of passing on, which would be a defence in the sense that the person claiming the tax back hasn't actually spent it because someone else has paid someone else's. The Court of Appeal dealt with this very clearly. It's in Appendix 1A, at tab 4, at paragraphs 313 to 336, which is EF 924. I managed to lose myself. Here we are. Normally it doesn't take me this long, my lords, to lose myself in the bundles, so I do apologise. Here we are, 924 to 929. Yes, 924, they introduce the question, is the defendant's argument that they were not enriched by reason of the interaction between ACT and shareholder tax credit precluded by the law? And I think the key passage, I can deal with it relatively briefly, is at paragraph 330 at page 927. Nevertheless, since we've reached a clear conclusion, we think we should state it. We take the view that the Supreme Court in the first reference to the first appeal has decided the point in such a way that makes it inappropriate for us to depart from what the majority there concluded. We'll return to this point in a moment. We also think that Littlewood's Court of Appeal decides that. And then para 333 at 928. This isn't, however, something that's ever been said so clearly by the CJAU. We don't think the FII and CJAU 3 is entirely conclusive on the point, but we do accept that the Court of Appeal in Littlewood thought it was. We refer in particular to the following citation where they said, it seems to us to be a clear rejection of the Court of Appeal's view that the test claimants and FII were not entitled to protection in respect of both existing domestic causes of action, which were capable of giving effect to their Saint Georges rights. And then the next sentence, the important one, we do not think that paragraphs 141 to 142 of Littlewoods detract from what the Court of Appeal had said earlier, as Mr. Ewart suggested it did. The National Court's procedural autonomy does not mean that a claimant seeking to enforce the Saint Georges right can be deprived of one of two available domestic remedies because of the application of defences or arguments that make it ineffective to give effect to that right. And I emphasise the word arguments because during the course of this extraordinary litigation, the Revenue have backed a number of horses. I think it's an each-way bet they've had. Sometimes it's a change of position, sometimes it's a subjective devaluation, sometimes there's no transfer of value, and now the latest one they've come up with is no unjust enrichment on the basis that as a technical matter of English law, enrichment is an element in the claim itself rather than the defence. What I would say, well, that's all very interesting, that it's an element of the claim and not the defence, but EU law really is not concerned with that. EU law is concerned to ensure that a Saint Georges right to a repayment of unduly paid tax is made. And it's made irrespective of the application of defences or arguments that would prevent it being made. Now, I know my learned friend is saying, well, you've got the Woolwich claim, and the Woolwich claim, we the revenue accept, cannot be subject to any defence like this. Why isn't it subject to any defence like this? They say for reasons of public policy, Bill of Rights, you name it, 1688 and all that. Fine. Why is that different from a claim made in the state for exactly the same thing for overpaid tax? Why should there be a difference? Now, with that rhetorical question, I turn that into a submission and say there should be no difference. If
Mr. Aronson, could I just ask you on that? Why does EU law care if it can see that domestic law does provide a remedy as required by EU law, as to whatever other remedies may or may not also satisfy the requirement of EU law? I think that's what I'm struggling with.
Well, my lord, but that's what the earlier Supreme Court hearing was about, not the one in February this year, but the one many years ago. And that's exactly the argument which HMRC raised, and it's a perfectly reasonable argument. You don't say, well, you've got the Woolwich defence with its 6 years limitation period, why do you need a longer one? But the view of the majority in that case was that since there are two actions available, one based on mistake and one based on just unlawful payment in itself, the Woolwich claim, each of them is protected by EU law. Each of them is therefore subject to the EU law principle of effectiveness, and each of them therefore cannot be subject to any defence or argument which would deprive the person who has wrongly paid the tax from getting it back.
And I'm so sorry, I should know, which Supreme Court decision are you referring to there?
In this case?
The first one back in 2012.
It's on my list here. It's FII Supreme Court 1, 23rd of May, 23rd of May 2012, and that was the majority view.
Though that was on the premise that there were two forms of action which were available to meet the case,
yes.
Whereas the submission being made against you under issue 18 is that, in fact, there's only one form of action in English law which is available to meet the claim.
Yes, I appreciate that that's what it is. It would mean that we were wasting our time in 2012. This argument now having been raised in 2020, we all ought to have realised how foolish we were. That because the revenue hadn't themselves thought of unjust enrichment as enabling them to say, well, that cause of action isn't made out because there was no enrichment, we're going to abandon saying there's a change of position, we're going to abandon this, we're going to abandon that. But as a result of that, everything else has been a waste of time. Well, my Lord, just say, your Lordship in the majority then got it right. Lady and Kidd, that famous case does apply. Lady and Kidd was actually referred to in this case by the CJEU in the second appeal, second reference. That there is no such defence. This is a Saint-Georges claim, just pay the money back. But if one is actually looking at it and saying, well, hang on a second, enrichment is an element, has to be an element of the unjust enrichment, has to be an element. And if all the arguments we've had this morning are, I'm wrong in all of those, so that you had to take account of the credit, even so, there was an enrichment because there's no way that all the money that was paid, all the ACT was reflected in credits which were actually given. Some credits would have been given to taxpayers in their tax returns, and they would have been making their tax returns a year later or whenever it is. In fact, if you go back to the early days, maybe when some of your lordships were at the bar, where you used to pay on a previous year's basis, right? I seem to remember no one what my tax bill was, because it always referred back to so long before. So the ACT would be paid, but the tax credit may not be claimed by an individual for ages. Pension fund would probably be quite assiduous in getting its money quickly. That makes sense. Overseas taxpayers may not have got the credit at all. So to say that the revenue have had this blinding flash of the obvious, that there's been no enrichment, and they were wrong last time to say change of position, it is really looking at the wrong way around. They were right to argue change of position. That's the truth, though. Their real argument was, we changed our position because we paid out these credits, sometimes quickly, sometimes slowly, sometimes never. Well, we changed our position. In principle, they could run that, but that's a defense. They could run that. They couldn't prove it because the way they presented their case was hopeless, absolutely hopeless. I think they did a better job in Littlewoods, I forget what it was in either case, in some other case, but in this case it was complete. It was almost funny watching their witnesses. But that was their real defense. They changed their position at some stages. It's not right to say that they were not enriched at all. So once you move into the area of what is substantively their correct complaint, assuming I'm wrong this morning, you are in the field of a defence. And if you're in a field of defence, you're operating in a field where there are two operative and protected causes of action, one the Woolwich action and one the mistake action. And once that is the case, then we are in the field very much of the Supreme Court hearing in this case in 2012. Both are protected by Lady and Kid.
Right, I can see if we're bound by Supreme Court authority to come to that conclusion. In a sense, that's it. That's an end of it. Although I would find it useful for myself knowing which paragraphs of that decision you're relying on. But if we stand back from that, do you have an answer as to why the principle of effectiveness in EU law requires there to be any more than one effective cause of action in domestic law that gives effect to the EU law right? At the moment, I can't see why EU law would be concerned to go beyond that.
Well, I'll put it this way, my lord. I'm glad you weren't in the Supreme Court in 2012, because the majority may have gone the other way. But
right.
I don't really want to re-argue that case. Not only did I argue it in the Supreme Court, I then had to argue it in the Court of Justice, because one of the issues that arose there was referred to the Court of Justice. So there isn't a short answer that would enable me to fit in with the timetable.
All right, fair enough. If at some point you could, purely for my personal benefit, direct me to the relevant parts of the judgment, not now, but at some point, I would be grateful.
I will do that. I've got that. I should be able to do it over in the evening by sending an email.
Of course, the issue there was a very different issue. What the case was about was the introduction by Section 320 and then Section 107 of the later Act of effectively a 6-year time bar for claims for the repayment of tax on the basis of unjust enrichment. There was already such a time bar for Woolwich claims, and the legislation had been brought into force in such a way that it effectively had been timed in such a way that people couldn't bring their claims. If they hadn't already brought their claims, they were caught by the retrospective application of a new limitation period. And the Revenue's argument was, well, it doesn't matter what we do to the time bar on unjust enrichment claims, because you've always got a Woolwich claim.
Yes. And
that was the argument which, if I remember correctly, the court rejected on Section 107, but on the 304, we doubted whether it could be right, but we referred the matter to Luxembourg.
Well, there was a split of opinion. Lord Sumption thought that it was wrong. All the rest of you, there were 7, if I remember rightly. 6 out of 7 thought it was protected. And there is, you're either protected or not. It's a bit like a vaccine, basically. If you have the protection of EU law, it protects you against defences. It also protects you against the peremptory truncation of a limitation period.
Yes. The vice essentially was that people who hadn't yet brought a claim could reasonably have thought they had 6 years from when they had discovered their mistake of law in order to bring the claim, and the effect of the legislation was retrospectively to disappoint their expectations.
Exactly. But it was based on the proposition that the action brought under mistake was itself, for unjust enrichment, was itself protected by EU law. If it's protected by EU law, there is no doubt, I hope there is no dispute, that the lady and kid principle operates, that there is no defence apart from the defence of passing on. So we're back to the issue whether it's protected by EU law. The majority view was that it was protected by EU law, both of them protected by EU law, and on that basis we say that there is no possibility of arguing that the disenrichment point can be used to defeat this claim. Now, I do appreciate that the Supreme Court does on occasion reverse its own decisions. I've noticed that recently, and I suppose there's nothing to stop you, if you really thought it was worthwhile, revisiting the 2012 majority decision. But
well, we didn't in that case. The case proceeded on the assumption that the taxpayers had a Deutsche Morgen Grenfell claim open to them. We didn't decide that because the point wasn't being argued, as I recollect.
Well, yes, but what the court did say, and the majority of the court said, that that the EU law would protect a Deutsche Morgen Grenfell unjust enrichment mistake-based claim. It would protect it. What my Lord Sales is asking was, why should it? And the answer is, well, you can decide one way or the other. But it's been decided once, and given the argument this morning, unless you think the argument this morning we're wrong, there's really no need to worry your heads about it. I mean, frankly, we're dealing about stuff that is it's archaeological, it's paleontology. All these things have gone, the time limits have all changed. I mean, it really, it's of no great significance. It may be interesting, it's of no great significance, and we've thrashed it out in 2012.
Well, if it's helpful for Lord Sales and others to understand it, a large part of the thinking was to do with the EU requirement that the remedies available in a domestic setting should also be available in an EU setting. And if a DMG claim was open in a situation where tax had been overpaid in breach of domestic law, then it followed from that principle of equivalence that they should also be available in a situation where tax had been overpaid in breach of EU law.
I mean, if I may say so, I can see the argument based on principle of equivalence, particularly in relation to procedural matters such as time limits. At the moment, although I have to think more about this, I was understanding the present argument to be based on the principle of effectiveness, that it's being said that there has to be a particular approach to the domestic law claim for unjust enrichment based on mistake of law in order to give an effective remedy for an EU right. And I mean, just speaking for myself at the moment, and I don't want to take up more time pursuing it, I do have a difficulty with that if one's defending on the principle of effectiveness, which is already satisfied ex hypothesized by the fact that there's another cause of action, the Woolwich one, which is effective. I can't see why EU law, in terms of the principle of effectiveness, needs more than that.
Well, my lord, I will send you the relevant reference. The
Yes, thank you.
decision was based both on effectiveness and on equivalence.
All right, I'll stop talking now and let you get on.
To the best of my recollection, I know I read it last week, and I've been reading an awful lot about the stuff in the meanwhile, but I'm pretty sure that it was both.
Right, thank you.
It started with equivalence and moved on to effectiveness.
That's because the effect of the legislation that was in issue was to render one of the equivalent remedies ineffective for a large proportion of taxpayers who needed to avail themselves of.
Well, can I just say that if I've lost on this morning, it's a pity that the case is going to turn on this.
Yeah. But if you've won this morning, you don't need this at all.
Exactly, my lord. And nor do you, if I can put it that way as well. It's a very difficult question. I mean, it was a fascinating case to argue in 2012 and in the CJEU, and one could see very clearly the arguments on both sides. So, let's now move on to shareholder. So the treaty credits. And this issue involves, the test case here is a Ford company. It was a Ford credit company, the Ford Motor Company's credit unit. So many cars are bought on credit. It was based in the UK. It had, I think, 13 operations in Europe, 2 of which were subsidiaries, and the rest, I think, were branches. And these were very large operations. And the overseas subsidiaries in Denmark and Austria, if I remember right, I can't remember for sure, they paid large dividends to the UK, which didn't carry tax credits. The only difference in the Ford case and the BAT test case is that the shareholders of the Ford Credit Company, FCE, were, I think, in the United States. It was a subsidiary of a United States company, whereas in BAT it had millions of shareholders, many of which were in the UK, some overseas. We've been looking until now, dealing this morning, with the case where the shareholders are in the UK, and that was the BT Pension Fund case as well. And what we've seen there is that there are 2 reasons why the shareholders should get the credit. The first reason is that the overseas dividend should have carried a tax credit, which should have fed into section 231, which should have fed into section 241, and allow the on payment to be made to the UK shareholders, their credit without the payment of ACT. The second reason, as in the BT Pension Fund cases, there is an explicit European court ruling that the UK shareholders are entitled to their credit. There's a very clear ruling, because looking at this from the perspective of equivalence, the whole purpose of the UK imputation system was to alleviate double taxation between the UK company and its shareholders, the UK shareholders. That's the whole purpose of the imputation system. And there was a requirement of EU law to make sure the shareholders got their credit, whatever arguments were raised by HMRC. When you're looking at the FCE case, there is a difference. The logic of the system, the section 231 and 241 system, the logic says that the United States shareholders should get their credit as allowed by the double tax treaty, they should get it because Section 231 credit has been received, and that's the equivalent of ACT. That's the logic of the system. But there isn't a compulsion. It's not mandated beyond that. There's no EU law protection as such for the American shareholder. So there is a difference, and that's the difference between the FCE case and the other cases. The other cases, both the logic of the system, whereby you are looking at the underlying dividend coming from the European subsidiary and saying, well, that carries a tax referable to the foreign nominal rate of tax paid by the subsidiary. The logic says, well, that ought to be enough. That ought to be enough to cover the onward transmission of the dividend under the double tax treaty. And it is enough. But it's not as clear-cut as the case we've been dealing with hitherto. Mr. Justice Henderson thought that the logic of the system applied, and he thought that we were entitled, if I remember rightly, the shareholders were entitled, and there's no question of the revenue getting any credit against the ACT for the amount of credits paid to the US parent. So that was his view. I think the Court of Appeal came to a different conclusion, I think reluctantly, and because, with respect, it seems they misread a key passage in the agreed statement of facts. It's dealt with, so I can deal with this, and I'm giving myself another 13 minutes for this, so good morning, my learned friend, Mr. Bremner. I will stick to my 3:15 time unless I get waylaid. If we go to the Court of Appeal, Second Court of Appeal, which is in Appendix 2, tab 64. Can that be right? No, sorry, it's tab 4. It's tab 4. Not 64, tab 4. Paragraphs 231 to 242. It's at pages 900 to 904. So it's issue 15, it's at page 900. Issue 15, can HMRC claim a credit against the repayment to FCE of overpaid tax, ACT, in respect to double taxation treaty credits granted to its UK parents? And then if we turn to their conclusion here, pause 1 second. Got the wrong reference here. Yes, here we are. It's paragraphs 238 to 239 in particular, and you'll see in 239 the error they make. Respect. First question, as it seems to us, is whether the judge was right to regard the treaty half tax credits as a countervailing financial benefit received by Ford US, which wouldn't have been available if the UK tax system had operated in accordance with EU law. He thought that Ford US would have had no entitlement to the treaty half credits if SCE had not paid the relevant ACT. That much, as it seems to us, was clear from the agreed statement of facts. Oh, sorry, I got it wrong. The judge was down on that. That much, as it seems to us, was clear from the agreed statement of facts. Upon the payment of the dividends which attracted those ACT liabilities, Ford US were entitled to receive a tax credit pursuant to Article 10.2 of the UK-US Double Taxation Convention. Now, pausing there, with respect, they're misreading the agreed statement of facts. That is a correct transposition of it, but they've misunderstood it. It's not upon the payment of the dividends and the ACT. It's upon the payment of the dividends which attracted those ACT liabilities, they were entitled to receive a tax credit. The question, however, is whether the judge was right to say that tax credits wouldn't have been available if the tax system had operated in accordance with EU law. Mr. Aronson says that they would have been available anyway because economically they were the reciprocal of the foreign corporation tax paid by FC's EU subsidiaries, not of the unlawful ACT, as the reasoning in FIICJ-EU1 makes clear. In our view, the answer to this question follows from our conclusions on the nature of the unlawfulness determined under the tax issues dealt with above. The relevant unlawfulness is the failure to treat a UK company in receipt of EU dividends on which EU tax has been paid in the same way as a UK company in receipt of domestic dividends on which ACT has been paid. Thus, FCE ought to have been in a position in which it could distribute its dividend income, even if derived from EU subsidiaries, to its US parents without paying ACT. Had it done so, however, the agreed facts made clear that the treaty half tax credit would not have been received by Ford US. Well, they do not make that clear, and I'll come to the agreed statement of facts. They simply misread the agreed statement of facts. So it seems to us that the first question in this case must be answered in the same way as it was in Pirelli. The fact that the reason for the unlawfulness of the payment of ACT is different in the two cases seems to us to be, as HMRC submitted, nothing to the point in the particular circumstances being considered under this issue. We shall, however, return to consider the broader implications of my 3 points under issue 17. And that was the broad issue. So they dealt with this before issue 17. If we go to the agreed statement of facts, which they say makes them answer it in a different way than the logic would determine, that's in Core 1, tab 7. At paras 31 to 37, that's pages 332 to 333. Statement of facts and issues. And the particular passages at page 332, if we read paras 33 and 34, the claim concerns ACT paid by FCE in the accounting periods which ended on 31 December 1995 to 1998. The full details of its ownership are set out in paragraph particulars of claim. However, insofar as it's relevant, then it tells you the shareholding and so on. And then 34. Upon the payment of the dividends which attracted the ACT in issue, the US parent companies of FCE were entitled to receive a tax credit pursuant to Article 10.2 of the UK-US Double Taxation Convention of 31st December. Credit was calculated as 1/2 of the ACT paid, less a UK tax computed at 5% of the dividend plus half the ACT credit. Ford Worker AG was not entitled to such credit as the terms of the UK-German Double Taxation Convention make no provision for any. So there's nothing in the statement of facts that says that the entitlement to the tax credit was dependent on the payment of the ACT. It was calculated that half of the rate of the ACT tax paid is the rate of ACT. It's paid. Not all.
Yeah, but surely if it's calculated in that way, it's dependent upon the ACT being paid.
I think we need to actually look at the US UK Double Taxation Convention. I'm not sure I can find that. Yes, I can.
Could I just put my point to you so you can deal with it in the course of your submission?
Sure.
At the moment, it seems to me that issue 15 arises in a different context from issue 17. As you explained in your submissions on issue 17, the credit to the outside shareholders was going to be received in any event, whatever happened to the ACT further down the system. Whereas it seems that in relation to issue 15, the what operates as the payment on to the Ford US company under the double taxation treaty is the very fact that ACT has been paid in the UK.
That seems to emerge from what I've just been reading.
All right. At all events, that's the point.
That's the point.
Which seems to be a significant difference between the two cases, as it seems to me at the moment.
Yes, yes, I quite see that. I'm not. I wouldn't contradict that at all. But I think it would be helpful if we actually read to see what the double taxation treaty says, because the statement of facts is a summary of it. It's Authorities 3, tab 30, EFP 4011. Excuse me while I go and get it. Authorities 3. And unfortunately, the statement of facts was a summary. And the reason it's a summary becomes apparent when you actually read the wretched terms of the double tax treaty, because it's in the usual Delphic terms of double tax treaty. So we have here, it's Article 10. This is the Double Taxation Relief Order 1980. Dividends, and you have 2. As long as an individual, this is sub-article 2, as long as an individual resident in the United Kingdom is entitled under United Kingdom law to a tax credit in respect of dividends paid by a corporation which is resident in the UK, Para 1 of this article shan't apply. And that is the case. There was a tax credit was payable generally. In these circumstances, dividends derived from a corporation which is a resident of a contracting state by a resident of the other contracting state may be taxed in the other contracting state. However, such dividends may be taxed in the contracting state in which the corporation paying the dividends is a resident, but if the beneficial owner is a resident of the other contracting state, the tax so charged shall not exceed the tax provided in subparagraphs A and B below. A. In the case of dividends paid by a corporation which is a resident of the United Kingdom, and that's what we did with FCE was a resident here, to a United States corporation which either alone or together with one or more associated companies controls directly or indirectly at least 10% of the voting stock of the corporation which is resident of the United Kingdom paying the dividend, the United States corporation shall be entitled to a payment from the United Kingdom of a tax credit equal to 1/2 of the tax credit to which an individual resident in the United Kingdom would have been entitled had he received the dividend. Subject to the deduction withheld from such payment and according to the laws of the United Kingdom of an amount not exceeding 5% of the aggregate of the amount or value of the dividend and the amount of the tax credit paid to such corporation. So, my Lord, that's the problem. The summary of the statement of facts paraphrased that in a way which led the Court of Appeal to assume this was, if you like, a Pirelli situation. The tax credit given by the treatment does not depend on the payment of the ACT. It simply depends on the value of a tax, half the value of a tax credit that a UK individual would have received. ACT was paid, it shouldn't have been paid because an EU tax credit would have fed into the system under section 321. And so when the Court of Appeal in this case said that the logic, if you like, was in our favour, but because of the statement of facts, they had to decide against us. I'm afraid the statement of facts was deficient. Now, that does lead to a question as to whether the statement of facts is, if you like, determinative. But it would be unfair on the claimant, that particular claimant, to say, well, had the statement of facts been more accurate, they would have won, but because it's inaccurate, they've got to lose. So I hope that addresses my Lord Sales's point. As I said, I hadn't read this for some time, and I wasn't absolutely sure that it did say what I thought it said, but it did say what I thought it said. And it says it in the most convoluted way. It is extraordinary how anyone drafting a double tax treaty would use language like that.
And just looking at Article 10(2)(a) little 1, I can follow the argument that the US company should get a tax credit equal to 1/2 of the tax credit to which an individual resident in the United Kingdom would have been entitled had he received the dividend. So if it stopped there, I can see forcing the argument that that is equivalent to issue 17 on your submission, that that's a tax credit that the UK resident would get in any event, and therefore the payment of the ACT is not a trigger for that. But what do you say about the words which follow, though, subject to the deduction withheld from such payment? Because that looks as though the fact of deduction being withheld from such payment, that is actually the ACT, is itself made a precondition for the operation of the tax credit under the double taxation agreement.
No, my lord, with respect, such payment is the payment of the tax credit. It isn't the payment of the ACT. The deduction from that is the tax credit is to be calculated in the following ways. A, start with how much a UK individual would have got. B, divide that by 2. C, subtract from that 5% of the aggregate of the dividend and the half tax credit, and now pay the balance.
But what value are you giving to the word subject to the deduction withheld from such payment?
Such payment is the payment of the tax credit. What I'm saying is that is the roadmap that's laid out. You start with the value of a tax credit paid to an individual in the UK. You halve it. You then reduce that by taking 5% of the aggregate of that half plus the amount of the dividend. And once you've done that bit of arithmetic, then the net value is the tax credit that goes to the shareholder. None of that has anything to do with ACT.
Thank you.
That's how it goes. So, as I say, the logic underlying my arguments this morning on issue 17 apply likewise, but without the mandatory treatment that a UK recipient of a tax credit gets as a matter of EU law, because this is a further extension through a treaty. But the Court of Appeal saw the logic, but thought the statement of facts led to a different conclusion, but the statement of facts were an inadequate statement of the actual position under the double tax treaty. And unfortunately, this litigation at various stages suffers from the fact that there are so many major issues that minor issues don't get thrashed out in the detail they would if they were discrete issues in their own right, coming before a court as the only case. And for that, I have to accept as much responsibility as my learned friend, Mr. Ewart, I'm sure, would as well. There are big issues and small issues, and the big issues usually take up an awful lot of time. Not suggesting this is an unimportant issue to FCE. It's very important. We're talking about very substantial sums indeed.
Mr. Aronson, would it be fair to describe the apparent statement to the contrary and the agreed statement of facts as a rare occasion on which your side agreed with the basic revenue theory that this all turns on the amount of the ACT that's been paid, and which you've been telling us all day has been rejected on numerous occasions by various courts?
No, my lord.
No, all right.
That would not be a fair description. I have absolutely no idea who drafted the agreed statement of facts. It wasn't me, my lord.
Well, I won't pursue it any further.
I mean, frankly, you know, you do an agreed statement of facts. You agree it. Maybe the revenue did a draft. We had a look at it. And we thought, okay, that's a fair enough description of the treaty, etc. We weren't poring over every single word in it. Maybe we should have done. 5 minutes spent there may have saved 10 minutes here. As I say, this is a very interesting point. Frankly, the logic means that FC ought to succeed, but it's not mandated, as is the case for the issue 17 dividends. My lords, I've overrun, but unless I can assist your lordships further, those are my submissions on issues, whatever they are, 15, 16, 17, 18, I can't quite remember the numbers, and 3 or 5. Anyway, I've finished my bit.
Thank you very much, Mr. Aronson. We'll turn then to Mr. Bremner.
Very grateful, my lord. I'm going to start, if I may, with issues 11 and 13 from Court of Appeal 1, Reefs and Expenses. That's our appeal. I'll then deal with our response on the separate interest issue, which is 26A and 10 from Court of Appeal 2. And thirdly and lastly, I'll deal with surrender, issue 11 at Court of Appeal 2. That's our appeal. On reliefs,
Mr. Bremner, before you go further, we're not picking up your voice terribly clearly. Perhaps you need to be, I don't know, but perhaps you need to be closer to the microphone.
I'm very sorry about that, Lord. I'd understood from the broadcast team that if I spoke at a conversational volume, that would be best. But if in fact I need to project more, then I will do so. And please tell me if I drop off again. Is that better?
Yes, it is.
I'll simply do that then. And we'll on reliefs and expenses, we deal with this in paragraphs 96 to 136 in our case, and I adopt those submissions. For my oral submissions, can I start by putting these two issues into context? Issues 11 and 13, they deal with a very common situation where the taxpayer company, in working out its corporation tax liability, used reliefs in working out the total profit that were chargeable to corporation tax. And here I'll be focusing on corporation tax on D5 income. I don't need, for the purposes of these issues, to get into the ACT system. There are 3 reliefs with which we will be concerned. The first 2 are management expenses and group relief. And as we'll see, both of those reliefs applied at the stage of working out the profits chargeable to corporation tax. In the case of management expenses, that happened automatically under the legislation. In the case of group relief, that was a routine adjustment to the taxable profits. Contrast, the third type of relief, double taxation relief, I'll call that, when I remember, DTR. As we'll see, that applied after the total profits had been worked out. So the sequence is management expenses and group relief, they've been taken into account in calculating the total profits, apply the tax rate to give a tax liability, and DTR is then given as a relief against the tax liability itself. And that has 2 important consequences, and I'll develop this. The first is that in practice, where, for example, management expenses had automatically been set off in calculating the total profits, not all of the available DTR would be used. And because there's no provision in UK law for carrying forward DTR, the result would be that some of that DTR would be cancelled out and wasted. And that issue arises even in relation to DTR for actual tax paid. So that's a problem before we even get to the foreign nominal rate credit that we now know was also required under EU law. The second consequence is that we now know that UK law was defective in failing to give enough tax credit, because it needed to give credit not only for tax paid, but also credit at the foreign nominal rate. And so the position is that both management expenses and group relief, they have been set off to reduce total profits in circumstances where the UK could not validly impose tax charges as a matter of EU law. And where we are in issues 11 and 13 is seeking to determine what the consequences are of that situation. And there are a number of potential routes to a solution that would meet the requirements of EU law. And which route is appropriate is determined in my submission by the nature of the unlawfulness of the UK provisions, and also the consequence of a purported utilisation of a relief in circumstances where UK law didn't give the necessary tax credit. Before I show you the provisions, Lewis, can I please make 3 overarching points? I'll develop these in my submissions, but could I just summarise them first? First of all, the UK provisions as they stood breached EU law because they prevented the double taxation relief from being carried forward. And we'll see that when we look at the Court of Justice's judgment in Salonen, which we discuss in some detail in our written case. And it's not seriously contested, that first point, by the Revenue in their written case, but I will show you Salonen because, and this is the second point, the nature of the breach is important when we come to working out how properly to remedy the defect in the UK system. Because what the court will have seen is that the Revenue, and this is in paragraph 72 of their case, and we'll look at this in detail, they propose a particular conforming interpretation. And in my submission, we will see that that conforming interpretation is eccentric and ill-founded. And that premise for the Revenue's case on the remainder of issues 11 and 13 is flawed. That's the second point. And the third overarching point is that it is the conforming interpretation that then conditions the nature of the remedies available. And my preferred submission will be that the claimants have good restitutionary claims, but if that's wrong, then reliefs which were purportedly expended, they must remain available for the claimants to use. For your Lordship's note, turning to the UK provision, we summarise those at paragraph 98 in our case, which is at electronic page 412. And I don't detect from the Revenue's case any real dispute about how this worked at the time. But can I very briefly show your Lordships the relevant statutory provisions so you have them in context before we turn to the substantive issues? These are all in Authorities Volume 1, Tab 3, and they start at electronic page 3058. Within the Income and Corporation Taxes Act 1988, we've used the version as enacted in 97-98. There is a later version which starts at 3166, but I don't think I'll need to go to it. No substantive difference arises from that. Can I just show you, Lordships, those relevant provisions called the Corporation Tax Charge? That's section 6.1 at the top of electronic page 3058. And you see it's charged on the profits of companies. And then over the page, 3059, section 8.1, A company should be chargeable to corporation tax on all its profits wherever arising. Then on the same page, in section 9 at the bottom, section 9 is telling us, if I can just cut to the chase, that the amount of income for corporation tax purposes, that's to be computed in accordance with income tax principles. So we look to those when we're doing the calculation exercise. 9.2 is the definition of income tax law. I don't need to worry about that. 9.3 is important. That tells us that you aggregate the various sources of income. This is the top of 3060. And the reason you do that, you see right at the end of subsection 3, that is to arrive at the total profits. And as we'll see, the concept of total profits, that's one that will come up again and again when we're looking at these reliefs. Turning over to page 3062 and section 12. 12 subsection 1, that's the mechanics. Put short, the charges for accounting periods, and it's on the full amount of the profits arising in the period. And of course, we haven't got this in the bundle, but the rate of tax, that would be in the relevant Finance Act for the particular year. So that's the way that the charge works. If I can just briefly show you each of the reliefs, I'll do this very quickly. Page 3072 gets us to section 75, and that's expenses of management. And halfway down the page, the court will see, in computing the total profits, there shall be deducted any sums disbursed as expenses of management. And so you see that deduction is automatic. There's no need to claim it. There's no decision to make. It's the automatic consequence of the legislation. And then in subsection 3, if the management expenses exceeded the profits, the excess management expenses are carried forward. Again, that was automatic. Just for completeness, there was a change in the structure of these provisions in 2004. And in the later version, that carry forward, it stops being within subsection 3, and it's provided for in section 75, subsection 9. You'll find that at page 3175, but we don't need to look at it. There's no substantive difference.
Just before you go on, Mr. Bremner.
Yes.
I had rather thought that management expenses would be deducted in computing profits in any event, but I see in subsection 1 of section 75 that a distinction is drawn between any sums disbursed of expenses of management, which we're told are to be deducted, except any such expenses as are deductible apart from this section. So what are the sort of expenses that section 75 is actually concerned with?
Oh, well, that's a good question. I hadn't come armed with an example, actually, but you could have expenditures deducted on general principles, so through the accounts, and then not knocked out by any particular barring provision, as your lordship will well know. And then this is a specific relieving provision. I can't immediately think of a particular item that wouldn't come in, but then would be saved. But if your lordship would like an example, I'll happily supply one.
No, I mean, it's just I was slightly jibbing without having mentally at the way you were putting it in terms of it being a relief. But when I was thinking, well, it's just how you calculate profit. But I see that there is, in fact, a distinction drawn in the legislation between what would be deductible apart from the legislation in computing profits, and something which legislation itself says is to be deductible in addition to that.
Yeah, absolutely so. And section 75(1) gets you to a place where if you have a problem applying the general principles, you would nonetheless get home under subsection 1.
Yes, okay.
It's presumably just designed to avoid a double deduction, isn't it?
Yes, well, you certainly couldn't have both.
Yes, I mean, if for some reason what could be a management expense has already featured in the accounts to reduce the profits, then you don't get it again.
Yeah, that would certainly, it will certainly deal with that problem. Yeah, absolutely so.
Yeah.
So that's all I needed for management expenses. Group relief is rather further on in this tab. It's section 402. And that should be from page 3118. There's quite a lot of detail on this, but I need very little of this to make my points. First of all, group relief itself, you see in section 402, subsection 1, top of 3118. And you see there's a mechanism for surrender by a company, that's referred to as the surrendering company, and then the making of a claim by another company called the claimant company. And then in those circumstances, those amounts may be allowed to the claimant company by way of a relief from corporation tax called group relief. So structurally, we'll find it's the same, because when you look at how this works, section 403 sub 1, which is over the page on page 3119, group relief, that is set off for the purposes of corporation tax against the total profits of the claimant company for the corresponding accounting period. And it doesn't matter particularly, but the point is made again, just for completeness, electronic page 3123, and it's section 407 sub 1. That's when it's dealing with the relationship between group relief and other relief being allowed as a deduction against the claimant company's total profits. Well, I hope I don't mind. I'm just seeing, I had a message from my solicitor saying that they think the sound is not terribly good. I hope it is. I hope I'm at least audible.
You are. If you were breaking up so much that we couldn't make out what you were saying, I would of course let you know. There is some distortion now and again, but it's not too bad a problem. Speaking for myself, I've been able to follow what you're saying perfectly well. Yes, my colleagues are nodding their heads.
Well, thank you. So that's group relief. Double taxation relief next. For this, I need to ask you please to go to electronic page 3132, and that is section 788 and following. And here there are two different kinds of things that can happen. The first, of course, is when there's a treaty in place, and that's dealt with under 788. And then if there's no treaty, there's unilateral relief, and that's section 790. Treaty relief, first of all, that's section 788, subsection 3, little a. Treaty relief from corporation tax in respect of income. And then section 790, if the court has page 3134. 790 sub 1, that makes clear that the tax is allowed as a credit against corporation tax. And then 790 sub 2, that's the concept of unilateral relief. And then subsection 3, in short, is telling you that unilateral relief is a relief you'd get under Chapter 2 if there were a treaty in place. And then within Chapter 2, all I need is page 3137, which is section 793. And you see in section 793, the way this works is that the credit reduces the amount of the United Kingdom tax chargeable. And last point on this, section 797 on page 3139. There's a limit on the credit, and you see in subsection 1, limited to the corporation tax that's attributable to the relevant income. So what you have is the DTR is a credit which is applied directly against the UK tax which is chargeable. Management expenses and group relief have already come in at a prior stage of working out the total profits. And so those are the two steps. First of all, work out the total profits and then apply the DTR, and DTR is capped. And just for completeness, I should say that the step-by-step approach that I've described by walking your lordships through the legislation, slightly late perhaps in our story, but it was made explicit in Finance Act 1998. And just for your note, it's Schedule 18, paragraph 8, and that sets out the various steps and shows in terms that you have DTR being taken into account after the profits have been calculated and after the tax rate has been applied. There's nothing controversial about that, but it makes explicit what already was being done on the ground in the provisions. Now, this morning, Lords, Mr. Ernson made submissions about the UFT system. And on UFT, I need simply to say that UFT doesn't create any relevant change for the purposes of this issue. And we explain why that is. In our case, it's paragraphs 98, sub 3, sub B, and paragraphs 117 to 18. And I don't understand there to be any dispute about that. So no one is saying that the introduction of the UFT provisions makes a difference here. Now, the problem that this system creates is that DTR doesn't get used, or not all DTR gets used, because reliefs are first taken into account. And because it isn't possible to carry forward DTR, the effect of that is that there is a cancellation of the DTR. And that, when we look at the Court of Justice's judgment in Salonen, we will see leads to a breach of EU law. And Salonen is what I need to show your lordships next. That's in Authorities Volume 2 at tab 21. And it's electronic page 3827.
This is a case called Haribo-Lakritson.
Yes, that's the main case. There were two cases heard at the same time.
I see.
And certainly Lord Reid and Lord Hodge may remember quite a lot of time being spent on Haribo in Prudential. I'm not going to spend any time on Haribo. I hope you'll be pleased to know. Salonen is the case that was heard at the same time as Haribo. We summarise what it decided in paragraphs 103 to 108 in our case, and I'll show you the relevant passages, which are mercifully quite short. But there are two key points. Salonen establishes that the failure to allow DTR to be carried forward is itself a breach of EU law. And secondly, the reason for that is that the failure to allow the DTR to be carried forward results in the overseas dividends being subjected to indirect economic double taxation. Now, Salonen itself, what you'll see when you look at the judgment, Salonen is case C437 of 08. And the court devotes most of its judgment to the Haribo case. What you see, if you go to paragraph 27 in the court's judgment, this is electronic page 3870, actually starting at paragraph 26. They introduce Salonen They've already set out a number of questions from Haribo in the previous paragraph. And then Salonen, so case C437 of 08, there are 2 additional questions that are being raised in that case. The reason for that comes from paragraph 27, because in Salonen, the taxpayer company, it had made an operating loss in the relevant year. And the question that arose was whether the DTR credit needed to be carried forward. And you see that particularly in the first question that's being referred by the Austrian court, which is paragraph 28.1. And the court deals with those questions at paragraph 148 in its judgment. So up till now, it's been dealing with Haribo. And then at paragraph 148, page 3889, the court turns to the questions in case C437 of 08. So that's Salonen. Typically, in paragraph 148, it reformulates the question that's being asked. And it's asking about the compatibility of the Austrian regime, which has an imputation method, so the credit method, for overseas source dividends, the exemption method for nationally sourced dividends. How does that comply with EU law? Or does it comply with EU law in respect of tax years in which the company receiving the dividends has recorded an operating loss and doesn't provide for the carrying forward of the credit? And there's also the second question was an issue about tax withheld at source. I don't need to worry about that for my purposes. There's a debate about admissibility, which I'm not going to take up time with. If I could pick it up, please, at paragraph 154. That's page 3890. So what the court is looking at here in paragraph 154 is whether EU law requires the credit to be carried forward where the recipient company records an operating loss in respect of the tax year in which it receives the dividends. Paragraph 155, you see the submission of the Austrian government, and they say, well, no, that's not necessary, because you see this just above the letter D. The member state's obligation to grant a credit, they say, extends only up to the limit of the amount of corporation tax for which the company is liable. So Austria says, well, that's enough. No obligation to do any more, and in particular, no obligation to have a carry forward. So if you have a loss in the particular year, tough luck. And if that means you waste your credit, too bad. But that argument, as we see at 156 and following, that argument is rejected. And the court's reasoning is critical for my purposes in addressing your lordships on issue 11 and issue 13. First of all, paragraph 156, there's the reminder of what's now well established, that the requirement is for equivalent treatment to be accorded to dividends paid to resident companies by non-resident companies, and there's a reference back to the ruling in this case in the first reference. And then paragraph 157, this is the contrast that the ECJ is making between the treatment of domestic source and foreign source dividend income. So you see, first of all, for non-resident companies, the dividends, they get included in the tax base. Where there's a loss, the dividend reduces the amount of the loss. And so the amount of the loss that can be carried forward, that's reduced to the same extent. And then by contrast, at letter G, then look at the position of the dividend from a resident company. There the dividend is exempt, and the result is the tax base is not affected. And so the losses that the dividend receiving company could carry forward, they're not affected either. Paragraph 158, that gave rise to a lack of equivalent treatment. That was the conclusion. Because in the case of the overseas dividend income, this is letter H, the reduction of the losses was liable to result, if the credit was not carried forward, in economic double taxation on the dividends in subsequent tax years when its results are positive. So if you take the dividend receiving company, if it's a company that's got some losses, so it doesn't pay any tax in year one, the losses are wiped out, and the consequence then in year two, if it makes some profits in year two, is it'll have to pay tax at that stage, and that is indirectly the economic double taxation of the original dividend in the eyes of the ECJ. And then contrast, this is at letter J in paragraph 158, contrast the position for nationally sourced dividends. For those dividends, there is no risk of economic double taxation because the exemption method is applied to them. So the point is that for the nationally sourced dividends, the dividend income, it never features as part of the profits of the dividend receiving company. And then you see at paragraph 159, the consequence is higher taxation. And then the conclusion in paragraph 160 that for the reasons set out in para 156, so that's leading back to the fundamental requirement for equivalent treatment, the legislation is precluded by EU law. And then just for completeness, on page 3891, para 161, the court looks at Austria's attempt to justify the national measure, and that's rejected. 162, they note that it's right that the tax credit only needs to be granted up to the level of the national taxation. But then at para 163, they refer back to their paragraph 158, and they say that because the tax paid abroad can't be carried forward, Austria is failing to prevent the economic double taxation of the foreign source dividends. So you see paragraph 164, second last line, for that reason, the measure can't be justified. And then para 165, there's a separate argument by the Italian government about artificiality. That's irrelevant. I don't need to take up time with that. And then the remainder, so 166 to 172 deals with a separate second question. I don't need those. I should just show you the answer, which is at the bottom of page 3892, and it's paragraph 173. And the answer is in that first bullet point. So if I could just ask you please to read from letter J at the bottom of 3892 to just above letter B on 3893. So you see that the breach lies in failing to permit the double taxation relief credit to be carried forward. And the reason of principle for that, you can see going back to paragraph 158, is that the Austrian system was failing to prevent the economic double taxation arising in subsequent tax years, and the results are positive. And so that principle, in my submission, it's clear from the judgment of the court that there is, and I can just show you this for completeness and very briefly, there's a more detailed explanation from the Advocate General, and it does give a little bit of further assistance, so I'll deal with that very quickly if I may. That's on page 3861 of the electronic folder. And it starts at paragraph 150 at the bottom of the page. This is the Advocate General dealing with that first question on the Salonen reference. And one sees at letter A, what's happening is that the possible loss carried forward, that's being reduced. And then so in a subsequent tax year, you get correspondingly higher corporation tax. 151, top of page 3862. In the final analysis, you end up with economic double taxation of the foreign source dividend. And then in contrast, para 152, for the national dividend, economic double taxation, that's definitively prevented by exemption. That's just like in the UK system for national source dividends. And then para 153, not compatible with EU law, it's disproportionate, and you see it letter D, because you can't carry forward the credit or deal with the matter in some other way. And then there's the submission from Austria about the cap on the credit, and that's paragraph 144, it's rejected at paragraph 155. And then para 156 at the letter G, you see the reason of principle that underlies all of this. The Austrian approach, it's not preventing economic double taxation because the loss carried forward is being reduced by the amount of the foreign dividends. And so, in the words of Advocate General Coquart, national corporation tax is thus imposed indirectly on those dividends in subsequent years. You see that at the end of para 156. 157 is a reference to similar problems arising in the context of the parent subsidiary directive. It's the same point of principle, that the objective of preventing economic double taxation wasn't attained. And so in my submission, what Salonen demonstrates and what I derive from Salonen is that EU requires double taxation relief to be carried forward. If that's not done, the member state will impermissibly be subjecting the foreign source dividend to economic double taxation. And that, as we'll see, in my submission, is key when it comes to addressing issue 11 and issue 13. Now, in the Revenue's written case in reply, there is no effort to challenge what Salonen decided. And there's no dispute then that if UK law imposed indirect double taxation on the dividends in a subsequent year, no dispute that that would breach EU law. There's also no dispute that as they stood, the UK provisions didn't enable the unused DTR credits to be carried forward. So on the face of it, the UK system didn't meet the requirements that are set out in Salonen. But what the Revenue seek to do is to offer a conforming interpretation, which they say meets the requirements of Salonen. And on their case, they say, and this is paragraph 86 in their case, that if you take that conforming interpretation that they suggest, then Salonen has nothing to add. But what we'll see is that the fundamental problem with the Revenue's submission on these issues is that the conforming interpretation that is suggested is, in my respect for submission, ill-founded. Can I just show the court what the suggested conforming interpretation is? It's paragraph 72 of the Revenue's case. You see that at electronic page 481, going over to page 482. And what's happening here is the Revenue seek to draw an analogy with Prudential, and they say, although there's no reference given, and as we'll see, this isn't actually what Prudential does, but they say that the essence of the approach was that the EU credit needs to be prioritised. And they then say, and this is the critical part, that the EU credit must be taken so far as possible to relieve the tax on the case 5 income that is subject to the restrictive measure. And what they then do, going over the page, is to say in their final sentence that that can be achieved by reading section 75 so as to exclude, so far as necessary, the case 5 income in question from total profits. And that is the conforming interpretation, which is then the foundation of the Revenue's written case on this issue. Because what they then look to do is to say that the management expenses have or may have expired. That's in their case at Paras 75 and 86. And secondly, they say the group relief is stranded. That's paragraph 87. But the problem, but it perhaps would be better if I addressed the court on this tomorrow. The problem with the revenues approach is that the conforming interpretation, which is the premise of those submissions, it simply doesn't work. And perhaps, well, if that's a convenient moment, I can tell the court why that is tomorrow morning, because I see it's 4 o'clock.
Thank you very much, Mr. Bremner. We'll adjourn now for the day and resume at 10:30 tomorrow. Thank you.